paperwork here for the development agreement, the road use agreement, there's nothing in the
Decommissioning?
decommissioning that was changed,
No.
correct? And the resolution, nothing that we were changing on this, correct? And so, the development agreement, the road use agreement, section here, we will go, that's, what you got there for us. Yeah.
You're saying citizens cannot, but it's, the BOA still could not challenge it, or the zoning administrator.
Any challenge now?
If you get your, I guess, by doing the settlement, are you getting a tough? I guess that's another question, like,
We're getting tough conditions on it.
from us,
This,
so they could challenge that within 30 days if they were like mad about us taking over versus them, correct?
I mean, it's in the ordinance that they can challenge now, they can challenge now without this.
I just feel like it's only fair that within 30 days, any county, office or individuals can challenge if they want to, because that's a right that they have. But once 30 days are passed, then it's too late. I think what you could almost do is take that first,
Ignore the BOA.
yeah, and you could also say the BOS agrees and stipulates that neither the county has jurisdiction to revoke, rescind, withdraw once issued to Salt Creek 2 and past the 30 days. Challenge time period or something like that. You'd almost take out the new paragraph, just say
Right.
past the 30 days. It's the same, it's similar, but I want them to have an opportunity, because we can't tell them, yes, we control their budget, but there's different areas where in the Iowa code, BOA and us are separate. So I want them to have an opportunity, if they so choose to, challenge the decision.
The next one is G, 2G.
Change the language, zoning certificate was updated. Did we accomplish what we were trying to do? I think that's good. What's everybody else's? Go ahead.
I thought good at first, then I'm rereading, including those issued at a later date. So what zoning certs would be issued at a
Maybe like the
later date?
aircraft detection lighting system, that would be a zoning certificate. Or if we wanted to add another med tower or something like that.
Maybe spell those out for, Met Towers, LiDAR, ADLS or something. What I worry about is like somewhere, I think it would be good to say, these are not related to repowering, because I know we want to update our repowering ordinance. That just could be an open-ended, like, oh, in 12 years you're gonna repower, and we just have to give it, so that's another thing that, would be good to put in here, that
That
none
would
of,
just say all zoning certificates related to the project, of the construction of this project. So you can't do repower.
Yeah, sounds,
That would be exclusive.
Does that work?
I'm okay with it.
I think so. I'll just kind of want to read through
Sure.
after today to make sure that there's nowhere else that we're opening the door for wide open approval for 20 to 50 years. And it was 12, but.
I think I even have to worry about 30 to 50.
Some people might be.
What was the next change, Sean?
It's all the way to, 3G.
Okay.
Let's see. Reaching.
Oh, and it's certain signers agree, just want it.
Mm-hmm.
Okay. Yeah, if it's a different company, that's right.
Yeah, I wanted to make sure I covered that. And I know like the company you're with was, in lawsuits back in 2020 with California. I mean, is that all resolved to where you did keep ownership, like back to the Salt Creek 3,
The judge ruled that this always was and
the
always.
2 and the 3, and the 1 you kept all those? Okay,
Otherwise, I couldn't have sold Salt Creek 1.
yeah. Yeah, I know, I think you guys were going to business courts or something, so I didn't know how that turned out. Okay, I like that in there better.
The next one's L. 3L.
What's that?
3L.
3,
Oh, is
Yep.
that last sentence that
Yep,
yes?
I think that looks good.
Okay. Number 9. Looks like more time spent on that than we need to go. The lawyers had a bunch of them. First one out. Never seen that before. But we've looked in the basement and wall, and it is not prohibited. It's just practice. You always stay accountable. So we went ahead and did any other county than Pima County, but I've been advised not to do it, but and you might want to get with your lawyer on this one too.
Okay.
But they have not found any, you can't do this. It's not practice.
So if we don't do it, then if it ever happened, how would it work, just in the
And I
court
guess
case?
we, the two.
We just come together either now or we come together later, is that how it
Yeah,
works?
we're somewhere, we're gonna have to agree to where it's gonna be.
Okay,
And if we get into a fight, and I hope, we never do, that's even harder to come up with a venue. That was their argument.
To decide on the change of venue.
Yes.
yeah, true,
Well,
they
we
could
gotta
just
get a
decide.
judge, of course, rule the first time.
Yeah.
Oh, I had to say, there was one more, I apologize. 3R. The 3O, excuse me, there's a 3O. That's where we talked about the meetings.
Yes.
For 30 days.
Yeah.
And we also had put in there from Ben's letter about the school,
Mhm.
we put it in here that it's zoning administrator in any county. Or, so the school board, I mean, the school bus people could be here, that meeting or whatever. Or the fire department, whoever would want to be in, we meet once a month. And we also put that in the road use agreement, but I still need to understand Ben on the first, number one.
On number 9, could we just say that we would, the parties agree that any dispute related to this agreement shall be brought in the Iowa District Court on a jurisdiction to be determined by the parties?
The problem is if we don't agree, how do we agree?
Yeah, you're saying agree in this, you mean?
Yeah.
Oh.
That was what the attorneys were really concerned about. If we're already at that point, we're not agreeing. This would be one more thing not to agree over.
Okay,
That was their concern.
gotcha. Okay,
But they also advised me to advise you guys to have your lawyer weigh in on this.
then you had 3A, it looks like that was in.
Oh, yeah,
1.3 million.
Yep.
So the other thing I saw was changed.
Yes, sir. I can have them send over a red line copy if you like.
Oh, it's all right.
And then, the appendix is, we fixed the appendix A and B, the thing.
Okay,
And then on A, we're gonna get to the last one, stats. They're putting that together right now, from all the decades stuff. We can add that to it, but it's in, it's in all 27, permits from the FAA, so we just have to go in there and pull them out.
one typo in the last, on the signature page on page 10 is 2 T's in development.
Oh, okay.
Typo.
Page 10.
Yep.
Oh, yeah.
So we're good with this, no changes now? Mark, we're good with this, no changes? You signed?
No, he's correcting a misspelling on that page.
Oh. Sorry.
I'm gonna do that, and then.
Then the couple items, it was that F point about after the 30 days, he's gonna check on that.
Yeah,
And then
And I'm gonna get,
related to this project on the zoning certs, make sure no repowering.
those changes, and then I'm gonna try to put Ben also.
He's recommended.
Yeah. Oh, what's up?
He's not in.
That's not in.
Yeah, we'll meet for a minute and go over the concerns you have.
Okay. Yeah,
Is that open?
I guess,
Trying to think of.
I have the email with me, to remember what it is,
Here, sorry.
You've got it from that, yeah.
yeah, just, I guess the load permitting and
What,
then,
the question was on the load permitting, we get the turbine manufacturer, Howard Trucking Company, and they bring in all the permits, they go and get all the permits. It's all state, requirement, and what are you asking for here? They were thinking, we weren't sure what you were actually asking for here.
I guess, I know, just making sure that we, I guess, the coordination, to get, the permit. I know that you hire, you know, a subcontractor or whatnot to get the permits.
Well, it seems like ATS.
Yeah, an ATF or something like that, yeah. But.
So you'd like a copy of the permits is what you're asking for?
Well, I just, for the ones that are for the county, I would like to have those.
What are you saying is there's state,
There's
state
state,
permits and there's county oversized permits?
yeah, and so we're, I think in the previous agreement, there wasn't, I guess your use agreement, there wasn't a clear line of that, you know, when 25,000 was paid per the road use agreement, the assumption was made that that included the permits, the roadside permits for the county. And so I'm just trying to make sure that in this instance, we do get our, you know, our county permits, paid for.
Okay.
So,
I mean, we have to get them now, right?
I mean,
Because whenever we move white loads, we gotta get permits,
yeah,
period.
through the state, but then I haven't gotten very many through the county. Cause it was, when I mentioned that, when we first started going, it was like, oh, we don't, that was part of the road use agreement for the overweight load printing, and I was like, okay. And so that's why.
Well, you have the county has a oversized overweight permit now.
Correct.
Okay,
Yes.
so we just have to follow that.
Correct, yes.
Okay.
So I just,
Not a problem.
that's all.
And then the weekly scheduled meeting, what do you, we've agreed to do it monthly. Is monthly enough?
Yeah, monthlies, I guess, decent. I know right now we're kind of been doing a weekly-ish. Usually, if there's not too much going on, or, you know, it's just kind of like, okay, this is what we got going on, but I mean, monthly would be fine too.
Okay.
If you need it more though, Ben, let's.
Yeah, I mean,
More is good, if you
yeah,
need it,
yeah,
do it, you know?
yeah, so that's,
I think it was more for the zoning administrator, they might be more like monthly or something, but for your standpoint, maybe we need to clear out
yeah,
as needed with the engineer,
Right.
weekly to monthly,
How about no greater than 30 days and more if needed?
right?
Okay.
Cause yeah, you're gonna need a lot of
yeah.
time.
I think that would work.
And then on the monthly, what we were thinking on the monthly, because we're gonna do it 30 days prior to construction and every 30 days thereafter.
Okay.
Is that's when we could do the transportation for the school.
Yes, just wanted, you know, have that coordination. I think I remember if I gave you guys the contact information for this big one or not. But, I just like to have something along those lines to make sure there's coordination between the school and you guys. If you're having to maybe, you know, there's a crane crossing and you know you're gonna go across, I mean,
During school, during bus hours.
during bus hours or whatnot, kind of coordinate with them.
What we could, I mean, what we agreed to earlier was set up this 30-day meeting.
Okay.
But And so that will give them a layout, and then we can do, what we should do is just like, okay, tomorrow, or like 3 days from now, we're gonna be crossing this road, or closing this road for whatever reason. Gotcha. Communication is key.
Yep.
And then under dust, well, there already is a, dust abatement in the road use agreement.
Yep, I would just like to have, once, have that dust control there prior to when you guys start, so we don't have to, once the dust does start flying, we don't have to be reactive, we could be proactive. That's the only thing, I was like, just,
Okay, I haven't read the road use agreement in a long time, but I thought that was already in there. Maybe I'm wrong.
oh, I did some light reading on Sunday, I don't remember seeing it, but
There is something in there about the.
I mean, the dust.
Yeah, there is, it's the abatement.
It's on page 6. Um, responsible for implementing corrective actions to respond to complaints pertaining to fugitive dust. And then talks about how the county owns their right to demand that Salt Creek to suspend its use of certain portions of the whole route in connection with the whole route hauling operations. If needed to comply with lawful demand, IODNR should arise. And then county understands the urgency. Yeah, there's nothing on, I guess, the timing on that. It talks about that it's needed. I guess that's what I was just wanting to ask, something along the lines of, let me get a proactive approach, I guess, with the.
Let me get with my team real quick and see if they can come up with some language that makes you happy.
Okay. I guess so, just having something along the line. Yeah, start within a week or something along those lines, but more.
Yeah, because what we like using is water trucks and or mag chloride.
Yeah. That's.
Usually we do mag chloride in front of people's houses.
Yeah.
Alex Tracy, is he with your, Alex Tracy?
Yeah.
He says in the road use agreement, number 16 requires that it is prior to hauling operations.
Well, there we go. Yeah, prior to minute. Yeah, there you go. I guess in 15 it doesn't state it, but in 16 it does, so.
Modern technology.
I guess there you go.
So you shut, we're good with that one then?
Yeah.
Okay. Okay.
You can hear about it not working, but it worked there.
That's good.
I was wondering why my phone was buzzing. He's gonna get hold of you one way or the other. So you be going work on road use agreement and I'll be back. Get this couple things cleaned up.
Yep.
Good with that.
Or, I guess we.
Those are your three things, and the last one's been taken care of.
Yeah.
The other one, we're gonna put in, coordination with the meetings and all that.
Yeah.
This one, we will abide by all county ordinance, oversized, overweight, permits.
Okay. And then you put that in the road use agreement?
Yes.
Okay.
Yes, now this, we're just gonna go work on the road use agreement.
Okay. Okay.
Okay, there's nothing else on the development agreement, right?
Because in the development agreement.
Other than
we
the-
talk about these permits,
Yeah.
so, it's covered in the road use. Okay.
Okay.
Thanks, guys. Yeah.
What's that?
I'll make some.
You guys considering whether you want to recess, we get to recess and then come up to the attorney. Can we catch him? Sure. How about that? Jurisdiction issue?
That's fine.
Just recess for 10 minutes.
Is this one?
Wow, what is all this?
We'll be back in the session.
Ma'am, miss, we're in session now. Please.
Jim, you can't close it for your wife.
Okay, I wanted to, get the language back before we would ever have a vote, but I think that we can make our comments then. The other night, we were asked to make some comments at the public meeting. Wanted to get everybody's, comments from the board, and we'll see where that ends up, I guess, and so do we want to start here and work our way down? Right. Go back this way. There's no.
I don't mind. I'll start with you.
My feelings, you guys know my feelings. I already said it twice.
All right.
All right, I have crossed out some stuff, and I have 4 pages here. We'll talk in the morning, comes early. It's my intention to vote for the development agreement. So on Friday, we received an 11th hour request to negotiate with Salt Creek Wind 2. Sean Roberts, who you all met, the owner of Nations Energy Solutions, graciously agreed to meet with us this weekend. We spent over 8 hours negotiating. In these last few weeks, there's been a groundswell of comments, messages, phone calls, and public statements, including our integrity. In these last few weeks, there's been announcement, comments, messages, phone calls, and public statements, including from integrity. Not just marketing, but other members of the board of supervisors. Additionally, alleged failures of windows and support structure have been grossly exaggerated. Rather than calling it misguided gossips or untruths, simply put, no. As I said before, based on truth and facts, please be sure of your facts. One such line making the rounds is Bob Bergstrom is writing and is the decision maker. That is a lie. Bob Bergstrom was in the negotiations for historical information only. Sean Roberts, the owner of Nation Energy Solutions, made all of the decision. The same group, the same small group. In essence, small group. No. It's a public meeting, that's a comment. Spoken originally at length. All of my farmers have only one is scheduled to get Several said the people trying to stop this are older and have made it while times were good. They are struggling, and the taxes from the projects will provide for lower taxes for them and better schools for their kids, born and unborn. They are looking forward and trying to keep their farms. I see this as a landowner right now. As I understand it, this is a legal project. If it is stopped using delaying tactics or unreasonable means, it can be a legal action. Those farmers who have entered into agreements with Salt Creek Wind 2 are waiting for the project to go forward, so they will receive their negotiated funds. The Salt Creek projects combined will net the county over an estimated $80 million in taxes through the life of the project.
The monies earned by the landowners will generate additional monies, most likely to be used in the county to diversify their finances. For example, paying their property taxes. Local cities are looking forward to the monies to ease their tax burden on constituents. Toledo City Council and the South Tama School Board voted in favor of the board to support the agreement. The Tama-Toledo Chamber of Commerce is also supportive of the agreement. In my public rounds, besides the people who frequent our meetings, I've met only 2 who said they were against the Salt Creek Wind 2 project. All the others said, stop wasting our tax dollars trying to stop it. Local business leaders I've spoken to also support the project. When I ran for office with the idea, it was for us to lower taxes. We ran into a funding issue and we partially fixed it. The increase in tax revenue from the CREX projects will help the county tremendously. With the proposed agreement, I've got 2 in here, so the 1.3 million in addition to taxes and fees will go into the general basic fund to bolster it and keep us from having to borrow from other funds to pay our employees. This is not a bribe. This is simply the amount of money Salt Creek Wind 2 would spend taking us to court. If we go to court and lose, we will not get the 1.3 million. None of the concessions that we have made in our development agreement, and we will still have the turbines. If we were to prevail in court, the normal course of action will be for the losing party to sue for damages. This will cost the county taxpayer dollars to defend ourselves yet again. This course of action is not a wise plan. We would still lose the 1.3 million and all the concessions. I have been accused of yielding to the threat of legal action. It is not a threat. We have sadly become a litigious society, and lawsuits replaced a handshake and honoring our word. The project, to use a legal term, is substantially compliant with our CUAX ordinances. For those looking to go to court, the precedent was set in the previous emergency injunction. Judge David Cox did not agree with any of our challenges. If we try this again, we will most probably lose. Delaying tactics are a dangerous practice and can lead to hefty fines. I will not be a party to them. I crossed those 2 out. The school superintendent, John Kane, in our recent forum spoke about change is coming. I agree with him. I grew up with most of our country agreeing with Superman, truth, justice, and the American way. That came from the old Superman radio and then TV shows. Now the motto has been redefined by DC Comics. It is truth, justice, and a better tomorrow. We're at a crossroads. Many would consider it a turning point. Do we hang on to the days of the buggy whip, or do we acknowledge technology has moved us forward by leaps and bounds? The demand for electricity is skyrocketing. So much so, there are discussions regarding restarting the Duane Arnold nuclear power plant in Lynn County. A legitimate business is here in Tama County to provide more electricity to our grid. They have contracts with farmers who are eagerly diversifying to save their farms, and are waiting on us to move forward. I urge my fellow board members to join me in voting for the development agreement. I added another note based on our conversations today. Deferring to the DOA simply is a delaying process. Our board has the legal authority to move forward with this action, and I believe with the information we've done today, we have taken this clearly to the point where we are compliant. Thank you.
Next to me. I'll go last.
Yeah, I wasn't gonna say anything, but the biggest problem with turbines to me is how it happened. And you talk about truth and justice, absolutely none in this project from day one. It's been all lies and pain and lies and just bullying. There's truth and justice. We sat through that. And I highly doubt out of how many farmers are getting these, maybe 5%, maybe 10 are struggling. 90% of these guys are the big landowners and the people that already got it. That doesn't make any sense. Now the 5%, God bless them. God bless them. If they need it to succeed, God bless them. But to use that for an excuse, that's not right, because most of these guys are the rich landowners. And like I said earlier, if the BOA comes back, and I'll agree with whatever they say. I just think that they can do some more digging, and this has kind of been hurried through. Today was great. I think we came down with some good stuff, but, I will always forever be against these, because it's been a scam from day one. Subsidies. At my first job I couldn't make a living, so I got another one. Nobody felt sorry for me. All right, it could have been, and there's a lot of family businesses, hardware stores, been handed down generations, didn't work, they didn't get subsidies. They didn't get work wind turbines, nobody felt sorry for them. It's just, and if you're losing profit, the government subsidizes everything so much that they're not gonna go hungry. It's just from the top, from the very beginning, way back to Al Gore, it's been a scam. A money pocketing scam. And the farmers, Mr. Byrne one time said, we are accusing, or we're saying the farmers are dumb. And they can't decide to do what they want to do on their own land. We're not the ones saying they're dumb. It's those guys in Washington D.C. making millions and millions and millions off these guys, dangling $30,000, $20,000 out in front of them to give up that land. If this is a real deal, those farmers deserve $130,000 a year, $120,000 a year. We're not the ones saying they're stupid, and we've never said that, but he made that statement. But there is somebody laughing at him, and it's those people in the higher up. It's just getting taken advantage of, and how it went through from day one. There was secrets and secrets here through COVID. And you talk about tactics from people wanting to stop this. I sat right here, and there's tactics from the last board and the HR to stop it. I can't number them. So it works both ways. So it's this, and I can almost guarantee if you take a country or a county-wide vote, no's would win substantially. Why that was never on a ballot, that was never on a ballot. That was snuck through during COVID.
Iowa's not a referendum.
Well, I'm just saying if it would have been.
You can't.
There's
no legal way to.
There's more people, what I'm saying is there's way more people in this county are against than there are for. And, if you heard, I talked to Kurt on the phone one night, and it's like, he had got a lot of money invested in this. I'm sorry. If you win, you win. You lose, you lose. Some people make bad investments. But just the way this has been worked through, I just can't ever be in favor of it.
Okay, mine is pretty similar to a few weeks ago. I agree, it needs to go to the Board of Adjustment. I know I sent this off to the board members here, but just to reiterate that there is a big challenge between 335 and in the Iowa Code and what we can do in the 331.301. So 335.10 Board of Adjustment, the Board of Supervisors shall provide for the appointment of a Board of Adjustment and in the regulations and restrictions adopted pursuant to the authority of this chapter shall provide that said Board of Adjustment may, in appropriate cases, and subject to appropriate conditions and safeguards, make special exceptions to the terms of the ordinances or regulations in harmony with its general purpose and intent, and in accordance with general or specific rules therein contained, and provide that any property owner aggrieved by the action of the Board of Supervisors in the adoption of such regulations and restrictions may petition the said Board of Adjustment directly to modify regulations. So that's kind of the code section, as well as the powers of the board, 335.15 Iowa Code. The Board of Adjustment shall have the following powers, and again, it's not shall, it's shall, which means it must. It's not, I'm gonna go 80 miles an hour because I want to. Number two is to hear and decide special exceptions to the terms of the ordinance upon which such board is required to pass under such ordinance. So what that says is, we have our ordinance, there's a list of musts, and the settlement, again, I enjoyed the conversation, it was good to finally meet with him and to talk through, but ultimately, they are not meeting our ordinance because they cannot do those must items, which is engineer certificate, make, model, height, you know, they can't do the studies because, you know, they don't know, is it gonna be 600 and whatever it was, 43 foot, or is it gonna be 500 foot? That's a huge difference for migration patterns and for all the different things, so ultimately, they're, what's going on here? Is it starting to die? It kinda keeps cutting in and out.
We have another
We have
one.
none?
This battery's pressure, pass it down over
Yeah.
to the batteries.
Let's switch it up. It's gonna drive me crazy.
That one off.
It shows up, can you guys hear me? So ultimately, it just, in the code, it says in Iowa code, and I'm gonna follow Iowa code, is if there's a special exception or a variance, it needs to go through the board of adjustment. Like Kurt said, if the board of adjustment wants to make special exceptions or conditions, that's fine. But right now, how the ordinance is written, we do not have the power. Can we make us have the power? Yes, but the ordinance isn't updated. I get tired of when people try to do what they think is right, and again, I think majority of people don't want it, there's a few of the project owners that do, but we're not gonna go around it just to, what we think, you know, we don't wanna be the presidents, you know, there should be boards and positions that are highly trained, they can go through the whole permit application. Back to our Tama County ordinance, section 1901.1, the Board of Adjustment shall hear and decide all cases where an application has been filed with the administrative officer for any of the conditional uses, which may be subject to protected restrictions deemed necessary. So again, that's saying that they would do that. Board of Adjustment, they do have jurisdiction, they're a separate board. 2103.2 in the Tama County ordinances is their job is to grant a conditional use permit. So that is their job to do that. 21.03.4 to grant a variance. So again, that's what I mentioned before. And it says, in the determination that a strict application of the terms of this ordinance relating to the construction or alterations of buildings or structures will impose upon the property owner unusual and particular difficulties or particular hardship, such variations of which the strict application of the terms of this ordinance being in harmony with its general purpose and intent, but only when the board is satisfied that a granting of such variance will not merely serve as a convenience to the applicant, which would be self-frequent too, but will alleviate some demonstrable and unusual hardship or difficulty so great as to warrant a variation from the comprehensive plan as established by this ordinance. And at the same time, such variance will not seriously affect any adjoining property or the general welfare. This clause shall not allow the Board of Adjustment to permit a non-permitted land use to occur in any district without a rezoning of the land by the Planning and Zoning Commission or by the granting of a code. So there's a lot of things to unpack there. One, we do have a comprehensive land use plan with the 60 CSR. So again, we'd be bypassing that. The board just passed it, the zoning commission, as well as this board here. My assumption is that's pretty good land over there. I mean, it may be a little more hilly than phase one. The other thing is you gotta actually change this to out of ag production into, almost like an industrial, right? That gets done by the Board of Adjustment. So there's just these steps that we have to do. And there's another item, in the Tama County Ordinance 2103.6. And that one is, in considering all appeals and all proposed exceptions or variances to the ordinance, the board shall, before making any exceptions or variances from the ordinance in a specific case, first determine that it will not impair an adequate supply of light and air to adjacent property, or unreasonably increase the congestion in public streets, or increase the danger of fire, or endanger the public safety, or unreasonably diminish or impair established property values within the surrounding area, or in any other respect impair the public health, safety, comfort, morals, or welfare of the inhabitants of Tama County. I don't know about you guys, but there's a lot of things in that one different item that are gonna be affected, and if we're picking, you know, we don't know if it's gonna be a 500 or a 643 foot turbine, likely that is gonna affect property values, it's gonna affect the surrounding area, it's gonna affect the, Otter Creek Lake, it's gonna affect our county shed that's right across from the substation, and our employees that are working there. There's gonna be some comfort things, they're gonna see it, they could have potential health issues with it. So yeah, I think there's definitely some risk there. Any more than? So that's kind of where I am at. I'm gonna vote no to all these agreements today. I appreciate the dialogue and the feedback. I don't think it's an actual like, throw it in the trash, we're done with it kind of a thing. I think it needs to be a no today. One, we just got these. I'm a person, these gotta come home to me and I wanna digest this. I wanna, make sure we get it through lawyers. I wanna make sure the public can weigh in, we get it online. And if it does get voted down, I'm gonna request that we put on the agenda for next week to allow the Board of Adjustment to have a hearing on this. Unless we can do that today, but that's kind of where I'm at. Let me make sure I didn't miss anything here. Like I said, that power of we can do everything, I read it earlier, but the 331.301, it's when you are doing it to protect county and resident property rights, or resident rights, property, peace, safety, health, welfare, comfort, and convenience. So I think we're in a tough spot there, and I think the Board of Adjustment is the one for code ordinance. They should be hearing it, and we get on the calendar as fast as we can, and give them that opportunity, and then we see what their decision is. Like I said, if they voted through, they voted through. If they don't, they don't. It's not our decision up here.
Okay. Final comments. Everything that we negotiated today, 1.3 million. The good neighbor agreement in and out. The decommissioning plan, anything extensive beyond our current ordinance. The decommissioning being updated every 3 years and having a bond filed in the amount of $1.5 million, or excuse me, 1.5 times, whatever the engineering certificate or study comes back as. In addition, the changes to the road use agreement. Salt Creek 3, being not sold or transferred. The 1,500 foot setbacks. The decibels from 60 to 50. All of the stipulations that we've made that they've agreed with go away if we vote this down today. Every one of them. All of the grant that we've made, over the past month and a half, in discussions go away. They go under our old ordinance. They don't need to meet, the concessions that they've given us. And if it goes to the Board of Adjustment, they end up in court one way or the other, because our attorney said they're going to, one way it'll be, solved is that it'll be denied and the wind company will sue us, the Board of Adjustment. The other way it'll be solved is if it's approved and then the landowner sue us. So then the other landowners who have the right to have the turbines on the property will also sue us. If you look at what that is, if it's, we don't know what the contracts say, but if it's $8,000 a year, $10,000 a year, it's one item. It's quite a bit. You put 27 turbines on there for 30 years, that's millions of dollars that they could sue us for, on top of the investment that the wind company has. And so we were working to try to avoid litigation. If this goes to the Board of Adjustment, I believe that we're going to end up in litigation either way. I think the attorney thinks that as well. The attorney clearly thinks that we're within our purview of the Board of Supervisors to make this decision. immediately after we, approved Salt Creek 1, the sentiment was that, 2 was going to be right behind it. We were warned about that. And so that's why we started to do the negotiations and try to get some concessions so that we would be able to avoid a potential lawsuit. So if it gets sent to the BOA, all of the things that we've already plowed through, is all gone, and then you get to follow the old ordinance. And not have to do all of the things that they've agreed to. Secondly, when we had passed one, there were comments that were made. One of them was made, I'm tired of all of this taking up all of the time. There's a respected county official that has said, with all of the focus and attention being put on this for all of this time, what else in the county is suffering? We can't address everything at the same time. Additionally, there was a comment, Kurt Elmer made the comment that said, if we already have 80, what's another 27? That's why we even started these negotiations. I thought we had a pretty standard consensus, and it wasn't a vote or anything, but just the consensus that people wanted to be done with it and move forward. There's a couple of times I have emails here from Heather that has gone back and forth, and she said if they get number 1, then they're gonna get number 2. If they got vested rights on 1, they're gonna get vested rights on number 2. Her own words. And so the contention, and the original contention was that there wasn't going to be any contention, that we were going to try to work something out with 2. And so that's kind of how we got here. We wouldn't have wasted all of our time negotiating a better agreement if we thought that this wasn't gonna pass. We would have just sent it over immediately. So that's I guess my comments. I thought that we had an agreement, from the board. If you say something, it means something. I take your word to be your word. And if you say, what's another 27, we've already got 80. You've already got, all of the concerns you have with Salt Creek 2, you've already got Salt Creek 1 and Albiona right next to it. There's already a ton of wind turbines, and whatever you're trying to protect this specific area from, we're not protecting the rest of the county. I mean, that's just an ignorant statement. And so I think that, tactically, it's not the right thing to do. We do have the power to solve today. I'm tired of spending the time. I don't want to spend any more money. The majority of the taxpayers, I would agree, they don't want it. However, that's not the question we're trying to answer. The question is, do we continue to spend county resources, give up all of the concessions that we have received to continue to fight against the project? I guess my final statement is, I'm trying to stop a lawsuit. There's nothing in this for me one way or the other. I could care less. I think it's the right thing to do. I'm gonna be able to do whatever I need to do. I'm trying to stop a lawsuit. I think that the delaying tactics and the obstruction, sending it over, is just trying to stop the project.
I'm the deciding factor, so let's vote on this and get it over with. That's all I'm gonna say. Yeah, the way I vote, I'll tell you how I feel when we get there.
I got one more comment here. So I guess Sean's not back. Why would we lose everything that's been negotiated? Is he saying that it's an ultimatum that we have to approve it today, if it's next week, or if it's after the Board of Adjustment? Or is he saying that it's all gone out of his words, or is he coming back?
I don't know if he's come back.
Is that a fair?
But we brought that to him. Essentially, if we can't come up with an agreement, that means that we're probably going to end up in litigation. That's our own attorney's opinion. So it's not a threat, it's not a scare tactic, it's what's going to happen. And so if we don't have the agreement, don't get the vote, we need to move on with our lives at some point. And I'm thinking that having him here, part of the other day at the Thursday night meeting, one of the issues was, the jurisdictional issue, I think we fixed that. We fixed all the things that were problematic to David and I, to you. They've essentially agreed to all of the terms that we've asked for, except for the $2 million. I don't know why we would vote I guess, to not move forward with the agreement. So I think with that, we can call the question, we could probably, take a motion.
But one thing though, I'd like
I was gonna
to, I'd
say,
like to
we
comment,
need to-
I did say that, but after 45 calls, I changed my mind.
Good.
And we had a good discussion one time, and you said, you don't care, but when you reform, your people want it. So that's why I felt why I had to change.
And
My
again,
word, I have,
That's fair.
when I say my word is my word, but I just,
That's why, I'm just explaining why we move forward.
yes.
Why do we move forward with it? Why did we spend another 30 hours of our time, you know,
Well, I
in
get-
a room, when we're going to just vote this thing down? We made it as good as we could. I don't know how much more, they literally caved to everything, other than, 2 million. But we just got an extra $1,000, added to it, so I don't know what better could we do to try to move it forward? But, procedurally, if somebody would want to call the question, we would take it.
I'd like to just add one other thing, is everybody keeps complaining about the time. I've been the wind person and I would handle it. You guys chose to not include me. So this complaining about time, you got elected knowing there's a wind issue. You don't wanna spend the time, you shouldn't have ran. Okay? The people have spoken and they don't want it. So I get sick and tired of, oh, it takes so much time. Do other stuff. Let me handle it, but you didn't want to. And again, I can sit here with Sean and have a great conversation. So don't give me this time thing. I'm getting sick and tired of hearing that. People's rights are important. This is money. All these different concessions, we're barely getting anything. I mean, our 2010 ordinance even says decommissioning is adequate. So if the BOA gets it, what's adequate? They might say a bond needs to be put in place, and they could do that. You know, like literally the 1.3, just a little bribe. I know it's not a bribe, but money thrown at us is all that we're losing out of it. But again, I want the BOA to do what they want. If they want to approve it, approve it. I wanted to just get that clear, but I thought we were gonna hear from public comments first before we vote. We never heard from them. I mean, Kurt, is that okay?
Yeah.
I know you wanna get it over, but I think it's important to hear the people.
Yeah,
And
in
I've
my,
been sitting here for 6 hours.
I already lost out on a bunch of money last week because I spent all my week on the phone.
yep, I know.
So, but, I mean, if someone wants to kick it back to me, that'd be great, but it's not gonna work like that. So let's hear what they have to say and let's vote on this and let's go.
Okay,
We can sit here and go back and forth all day long.
yeah.
One comment. Are you at all concerned about bypassing the other boards in this county? I believe you 5 appointed the members to the Board of Adjustment. You must have had enough
Can you
faith,
speak up?
you must have had enough faith and enough trust and enough confidence in them to appoint them to those board positions, otherwise you wouldn't have appointed them. I understand the situation you're in. I get it. I understand. You're trying to get a good deal for the county. But are you establishing a dangerous precedent for this county by not utilizing the other boards that you have in place? I realize you have the final decision to make. I understand that. But why have all these other boards in place if you're not going to utilize them? To me, that leans more towards dictatorship than democracy. You're going to have a very hard time getting people to serve on your other volunteer boards if this is the way that business is going to be conducted in Tama County. So I understand the bad situation that was thrusted upon you 5. But I just worry about how people are going to interpret this, that all the other people that are working on these boards and are giving their time and their volunteer hours, why should they put in the depth of hard work if their opinions aren't going to be respected? So I hope it doesn't establish a dangerous precedent, Mark. I think that's something you need to think about. I know this is a special situation, but I don't know, it just doesn't sit well, to be honest with you. Thank you.
Anybody else? Good.
have, Patrick Cornwall had said that, it was either 2I or 2J, about the good faith, and if that is a two-way street, the paragraph should specify the parties anywhere it says the county. And that it falls out that it's both ways.
Okay, thank you.
If nobody else wants to talk, I will. You five took an oath of office to uphold the law. Heather just quoted the Iowa law saying that this should be going to the Board of Adjustment first, not you. And it says specifically in the code, the Board of Supervisors does not have the authority. Either enforce, hold up, and do what your oath of office said, and follow the code, follow the law. Because if you don't, if you vote for this, you're voting against your own oath of following the law. So do what's right.
I have a couple of questions.
We're not answering questions, but if you
No.
have a comment, you can make a comment.
I have a conflict about the road use. Said, quoting Sean versus what is in this agreement. The Chronicle said that it would just be maintained for the roads as long as they are here. But he says in here that that they'll be maintained forever as long as the turbines are out there. Then also, so yeah, we can't answer that. You're right. Then also, if this is such a great thing, then why don't we just fill up Tama County lands? Tama County owns property, we've got the whole Tama County home property, why don't we just fill that all up with turbines if this is such a wonderful thing? And then I thought that Bob Bergstrom owned Salt Creek, and he was the CEO, but this fellow says, Sean says that he's been on board for 11 years. So I don't understand that either, but for history and clarification for all of us who are local people, I want to thank you five supervisors for your many hours and months of work to practice and protect our county, both on the north and south side. Our five zoning members also, and our five Board of Adjustment members, you guys all care deeply for the land stewardship. And of course, the boards are led by Administrator Laura. Those boards have put in hundreds of unpaid hours to make regulations to protect Tama County land because they love this earth that we call home. All of this was done in just 2025, not knowing if anything that they would be doing would ever be heard or cared about against big corporate money. And I want to personally thank the very courageous citizens like Steve Gerlach and our families who have been sitting back and putting up with this and all the hours that we've been gone from our work sites at home to come out and tell truth so that we would all kind of know what's going on as much as possible. It took a lot of guts for some of these guys, especially when they've been gagged and threatened. And yes, you can call it confidentiality all you want, but anything that's done in secret, in darkness, under the threat of harm or harassment is a gag order. We are being divided and conquered as families. We're disagreeing about signing over generations of lands for 30 to 35 years to a global, international, unknown bunch of slick salesmen and women. This has been ongoing for 5 years since the China COVID coronavirus, but it sounds like it might have started 10 years ago with phase 1 in the northwest Tama County area. Only 4 weeks ago, we were finally given maps. They're laying right there to show us a visual of phase 2, only 4 weeks ago. To the north and to the east, just only a couple of miles from where we're sitting right now. Most of the residents in this county have no idea how close the 27 turbine intrusion is going to be. Our supervisors you guys have been trying to protect us from it with a moratorium in place since January 6th until new wind ordinances could be updated from our 2010 outdated wind protection version when turbines were about 250 feet tall.
How much longer you got, Karen?
2 minutes.
30 seconds.
And we all heard that phase 3 is still a secret. 3 weeks ago, we were told the city of Toledo had partnered with wind and solar to expand the profit from farmlands. 2 weeks ago, we were made aware that STC was working hard with Wind and Solar Creek and the city of Toledo to gain huge tax revenues from the wind companies if the companies don't go belly up, which is normal for a lot of these companies. And so the supervisors were not made aware of the many private meetings over the last couple of years
Make your final point, please.
to push this all forward, to save the schools, the STC system that have been having a lot of trouble for a long, long time. And I would like to say that they have had trouble because they threw out God and they threw out Jesus. STC, South Tama County. Thank you.
Thank you. Anybody else?
I have a letter that was sent in that they asked to be read. It was the email we all got.
Okay, we've already, have you read the email? We've read it.
The comment that she ends with is, it would be nice if the supervisor could send a response, so we know that at least it was read by one of you and not just lost in a file, filed in our teeth for trash.
We read it all. We all read it. Anyway, I got it in the email. You guys got it?
I'll just make a quick comment. I believe it was last Monday, I believe it was Linda Moeller, and made the comment about the 911 radio system and any interference with windmills and their radio system. Obviously, if something perks my interest, when it involves my office, specifically if it relates to the turbine project, I wanted to know a little bit more and be informed about interference in the windmills that are being constructed. I reached out to Sean and Bob, and I was able to look at both of the third-party studies that were conducted. I also spoke with Jacob, our 911 director, who just came in a few months ago, caught him up to speed, and we then had a meeting with Raycom, the one who built our radio tower project, to discuss mainly when I took over as sheriff. Obviously, when Jacob took over as our 911 director, there wasn't a whole lot of conversation about windmills and possible interference. And once Linda made that comment, it obviously spiked my interest. And if I get asked, I want to be able to have an informed answer. The nice thing about Jacob is he's very savvy when it comes to Google and Google Earth and all that. Long story short, he was able to plot all of the sites in phase 1 and phase 2 and the microwave path for each of our tower sites. And in discussing that with Raycom and Jacob, and I believe David Turner was in part of the conversation as well. I also conferred with Tyler Sell, who is on the 911 board, who was part of the decisions back when this was all first brought up. And at this time, there doesn't appear to be any interference. I can't say without a shadow of a doubt that there's not going to be any interference, but based on all the studies and the conversations that I've had with all the pertinent players, there's very little interference that will be affecting our radio system with the windmills. And I say that only because when Linda mentioned it, I wanted to be informed to make sure. Obviously, I'm not trying to reinvent the wheel and or have all these studies completed again, but I wanted to make sure that I was informed. If there was an issue, I would like to bring it up because I was also informed that because the radio towers were already there, they're already FCC licensed, if there is determined to be any interference with any windmills, it is the company's responsibility to rectify that interference. And that's an FCC guideline, and I don't want to say a law because I don't know if it's a law, but obviously if you're going to get permits for the FCC and there is interference, it is the windmill company's responsibility to rectify that. So I just wanted to let everybody know that because obviously it perked my interest and I wanted to make sure I was informed, but as far as the radio our 911 radio system is concerned, I feel very strongly that there won't be any interference, and if there is, we'll be calling.
I have a comment. Berlin Wolbeater, supervisor right here looking out for the landowners in the shadow of this project who will live with this the rest of their lives as Heather. Her careful review, questions, revisions, and concerns are only meant to protect everyone, and it is appreciated. Limiting the further increase in height would be important to us. This isn't just about what works for the next wind owner, as it needs to work for us too. Nothing should be voted on until every supervisor understands every term of this agreement as revised. Careful consideration now will prevent regrets later. Federal changes are not our fault.
You want me to stand, or I have a loud enough voice?
Yep, you're good.
A lot of these things have been a little changed because of what happened this morning in your discussion, so you have to bear with me and put in the correct amounts. But as of the public meeting on Thursday, September 11th, the general consensus is that the board will be accepting the settlement with Salt Creek Wind 2, and now for 1.3 million. Since that meeting, I researched the WEX of NextEra FPL in Wyoming, the state of Wyoming and Iowa, who is now the owner of Salt Creek 1. If you go to NextEra's website, you will find verbatim the same offers and corporate fast speaking that Tama County has been offered, bringing economic opportunities, landowner payments in Wyoming, 72 million for one project, Winnebago here in Iowa, 40 million, Clinton County, 180 million. County tax revenue in Wyoming for this particular site, 97 million. Winnebago, 100 million. Clinton County, 200 million. This is all over 30 years. However, if you notice visiting these sites, there's a tiny asterisk after all these numbers. At the bottom of each page, after the tiny asterisk is the wording, estimated subject to change. If anyone has never seen those words added to a contract, it usually means the numbers are not going to change in the favor of the recipient. The settlement agreement follows NES to pick and choose which county laws it's going to obey. When you file an app, there's no guarantee of approval, whether for a bank loan, a job, scholarship, etc. That's why it's called an application. It is obvious NES rushed this CUP application solely to bypass any moves by the new board of supervisors. NES thereby did not fill out all required information for Tama Code Ordinance 6.1, Section 6, Part Q, requiring all information on turbine construction. It is not the responsibility of the Board of Adjustment or the Board of Supervisors to allow said owner of Salt Creek Wind 2 to bypass required information because their bottom line could be affected by outdated equipment. This is their issue, not the citizens of Tama County. NES decommission plan also states that only equipment above 48 inches, above 48 inches in the soil will be removed. Research indicates that upon completion, turbine bases are typically covered with up to 15 feet of soil. This allows for 350 to 500 cubic yards of concrete and 80 to 120 tons of rebar per turbine to remain buried in Tama County until, one, landowners decide to dig down 18 to 30 feet to remove each base, or two, the bases will remain under our precious soil until Mother Nature sees fit to rust out the iron and break down the concrete. Do we want this going into our groundwater supply? Also, it's been studied, disappearance of earthworms around tower bases because of the vibrations in the soil. It either one, drives these worms deeper into the ground to escape the vibrations, or two, they disappear altogether. And that, the earthworms being a big reason why we have some of the top agricultural land in the world, it could be an issue. We also have the bats that are killed and disoriented by lights, killed by the spinning props, and quite possibly destruction of migrating bird routes. Please consider this information before settling the small amount offered by mega corporations that is in NextEra's instance has received $8.8 billion from we the American taxpayers already. 1.3 million is like one of us finding a penny on the curb. According to the words, it must have been NES, they stood to lose 2.5 million per month if the moratorium had gone into effect. Yet Tama County is willing to settle for less than half that amount for the entire settlement. Once again, I ask the board to continue working on fine tuning this settlement. A David and Goliath story is in the making, and as history serves me properly, David stood tall and won. Thank you.
I'll call the question.
Question's been called, it's undebatable. We'd have to vote on calling the question to eliminate debate in public comment. All those in favor of ending debate, say aye.
Aye.
Motion carries. The question is, do we approve? We'd have to make the motion, I guess, to approve settlement agreement, development agreement, resolution, and road use, I say decommissioning plan. Okay. All that are listed on the agenda, we need the motion to approve.
Make a motion that we approve decommissioning plan, the development agreement, the road use agreement, the resolution 1915-2025B. Authorize the chair to sign all documents within the agreement.
Okay, it's been moved. I will second it. We'll do a roll call.
Elmer,
Nay.
Turner,
Aye.
Knibble,
Nay.
Dolan,
Aye.
Pepper.
No. Okay, motion fails. It will automatically, stay where it's at. There doesn't need to be another motion to send it to the Board of Adjustment. It sits there since December 20th of 2024. Or, excuse me, 2024. And, so that would wrap up our conclusion of the development.
So what you're saying, the BOA doesn't have to look at it?
We adjourned at 3:03.
You didn't say
I
that.
think he means they can meet on their
They
own.
could meet